Before we begin, a quick and important disclaimer. The information presented in this video is strictly for educational and entertainment purposes only and does not constitute professional legal, financial, or psychological advice. Family law, marital dissolution, asset division, and custody regulations are highly complex and vary significantly across different jurisdictions, specifically from state to state within the United States. What applies in a community property state like California or Texas may be entirely different from an equitable distribution state like New York or Florida. I am not an attorney, a financial advisor, or a licensed therapist. The historical trends, academic studies, and case studies discussed herein are intended to provide a broad sociological and economic overview of divorce as it pertains to men in the United States. Viewers must conduct their own extensive due diligence and consult with qualified, licensed professionals, such as board-certified family law attorneys and certified divorce financial analysts, before making any decisions regarding their personal relationships, legal standing, or financial assets. Do not use this academic discourse as a substitute for individualized legal counsel. Imagine building an entire life, brick by brick, decade by decade. You invest your time, your capital, your emotional bandwidth, and your very identity into the construct of a modern American family. And then, statistically speaking, there is a coin flip chance that the entire structure will be legally dismantled, often leaving you navigating a labyrinthine judicial system that you fundamentally do not understand. Here is a reality check grounded not in internet rhetoric, but in peer-reviewed sociological data. In the United States, nearly 50% of all first marriages end in marital dissolution, and the statistical probabilities of divorce only increase for second and third marriages. But here is the statistic that completely shifts the paradigm and the one that sociologists and demographers have been studying intently for the past 3 decades. According to comprehensive research spearheaded by organizations like the American Sociological Association, women initiate approximately 70% of all divorces. If the marriage involves college-educated partners, that initiation rate skyrockets to nearly 90%. We are not here to assign blame, point fingers, or dive into the toxic echo chambers that so frequently dominate this topic in online forums. We are here to look strictly at the academic discourse, the rigorous empirical data, and the historical trends that explain why this is happening and, more importantly, what actually happens to men when the judge strikes the gavel. For generations, the narrative surrounding the American man in divorce has been heavily polarized and steeped in cultural mythology. On one side, there is the societal assumption of the financially resilient bachelor who bounces back effortlessly, unburdened by domestic life. On the opposing side, there is the pervasive narrative of the completely decimated father, financially ruined by insurmountable alimony, and entirely alienated from his children by a fundamentally biased family court system. Which narrative does the data actually support? The truth, hidden deep within longitudinal studies, economic mobility tracking, and psychological journals, is far more nuanced, incredibly complex, and utterly vital for every man in this country to deeply comprehend. We are going to examine a phenomenon that researchers define as the standard of living drop, a documented economic plunge that affects men quite differently than women over the long term, despite persistent cultural myths to the contrary. We are going to examine the shifting landscape of child custody, tracking the evolution from the historical tender years doctrine to the modern legal presumption of shared parenting. Furthermore, actual case studies reveal a massive, frequently devastating gap between what state statutes declare and how those laws are practically applied in county courthouses from the rural Midwest to the densely populated Eastern Seaboard. Consider the growing phenomenon of gray divorce, a term utilized by sociologists to describe the doubling of the divorce rate among adults aged 50 and older in the United States since the 1990s. Men in this older demographic face an entirely unique set of potential outcomes, including the complex division of retirement accounts, the splitting of pensions, and the terrifying inability to recoup lost financial ground due to a severely shortened remaining tenure in the active workforce. This is not merely a young man's crisis. It is a structural reality that spans every generation of the American male populace. If you do not understand the underlying mechanics of this system, the historical precedent that built it, and the statistical probabilities relevant to your specific demographic, you are walking into one of life's most profound socio-economic transitions entirely blind. What we are doing today is systematically dismantling the fear, the anecdotal hysteria, and the rampant misinformation surrounding male divorce in the United States by replacing it with empirical evidence, academic research, and historical context. The core problem this masterclass solves for you right now is the total asymmetry of information. Right now, if an American man faces the prospect of marital dissolution, he is immediately bombarded by horrific anecdotal stories from coworkers, predatory legal advertisements promising aggressive representation, and highly emotional advice from peers that lacks any foundation in legal or economic reality. This discourse is your academic anchor. By the conclusion of this extensive exploration, you will possess a comprehensive, data-driven framework regarding the modern American divorce apparatus. We will explore the economic models of asset division, contrasting the historical trends of sole breadwinner alimony with the modern realities of dual-income spousal support calculations. You will understand the profound sociological shifts that have redefined paternal involvement, backed by child psychology and developmental studies that demonstrate the critical necessity of the father's active presence. We will analyze how those very studies are currently being leveraged, both successfully and unsuccessfully, in contemporary custody litigation. We will dissect the potential outcomes of contentious, high-conflict litigation versus collaborative divorce and third-party mediation, analyzing rigorous cost-benefit ratios that could dictate your personal financial stability for the next 20 years of your life. Furthermore, we will delve deeply into the psychological and physiological toll of divorce on men. We will scrutinize the sociological concept of the male deficit model in emotional expression, analyzing how societal expectations condition men to rely almost exclusively on their spouses for emotional and psychological support. Consequently, when the marriage dissolves, the resultant social isolation leads to documented, statistically significant increases in morbidity, stress-induced cardiovascular events, and alarming spikes in clinical depression correlated directly with marital separation. We will review peer-reviewed public health literature detailing this phenomenon, providing you with an objective clinical lens to view your own psychological well-being during a crisis. This is not simply about losing half of your tangible assets. It is about understanding the systemic restructuring of your entire socioeconomic and psychological standing. We will evaluate case studies of high net worth uncoupling, the specific legal implications for middle-class fathers fighting for 50-50 physical custody, and the devastating impact of prolonged, combative litigation on generational wealth and family stability. You will learn how the legal concept of the status quo dictates the entire trajectory of a case before the very first legal motion is ever filed. You will see exactly how the academic community views the evolution of the no-fault divorce, a profound legal revolution initiated in California in 1969 that fundamentally altered the fabric of the American family and created the complex judicial landscape we are navigating today. We will not offer you guaranteed strategies or make any promises that you can outsmart a seasoned judge or opposing counsel. What we offer is unparalleled, unflinching clarity. We are charting the actual territory, complete with the hidden pitfalls, the historical precedents, and the stark statistical realities. Whether you are actively navigating a separation, contemplating the future of your current relationship, or simply seeking to intellectually understand one of the most significant socioeconomic drivers in modern American society, this discourse will equip you with the knowledge that most men only acquire retroactively, long after the financial damage has been done and the final decree has been irrevocably signed. You are about to step out of the dark, out of the realm of internet speculation, and into a structured academic space where the curriculum is the reality of your life, your hard-earned assets, and your future trajectory. To understand the precise mechanics of how this trajectory is altered, we must first examine the foundational architecture of modern marital dissolution. As we navigate the complex socioeconomic landscape of 2026, the legal framework governing divorce is still fundamentally anchored in a legislative revolution that began over 5 decades ago. Before 1969, obtaining a divorce in the United States required proving fault, such as adultery, abandonment, or extreme cruelty. This required litigation, evidence, and a judge's ruling that one party had actively destroyed the marital contract. Then the state of California signed the Family Law Act into effect, creating the concept of no-fault divorce. This meant that a marriage could be dissolved simply due to irreconcilable differences, with neither party legally required to prove wrongdoing. While sociologists broadly agree this was a necessary evolution for personal autonomy and domestic safety, the unintended economic consequence was the creation of a massive, highly streamlined administrative apparatus designed to rapidly liquidate and divide household wealth. Imagine, if you will, an average American citizen facing this apparatus today. Let us look at a case study of a man named Robert, a 45-year-old regional logistics director living in Ohio in this current year of 2026. Robert earns a solid upper-middle-class income, contributes aggressively to his retirement accounts, and pays the mortgage on a home that has appreciated significantly over the last 15 years of his marriage. Like many men in his demographic, Robert operates under the assumption that because his paycheck predominantly funds the primary investment accounts, those accounts are somewhat shielded by his individual effort. This is the first and most devastating cognitive distortion men face. In the eyes of the family court system, marriage is not merely an emotional partnership. It is a legally binding economic enterprise, an overarching corporate entity. When the no-fault petition is filed, Robert is not viewed as an individual earner. He is viewed as a partner in a dissolving corporation. Every dollar deposited into his 401k, every fraction of equity built into the family home, and every stock option granted by his employer during the tenure of the marriage is strictly subject to division. This leads us directly into the concept of equitable distribution versus community property, a jurisdictional divide that drastically alters potential outcomes for men depending entirely on their geographic location. In community property states, the marital estate is generally divided straight down the middle, a strict 50-50 split of all assets and debts acquired during the marriage. However, in equitable distribution states, which comprise the vast majority of the United States, the court divides assets based on what a judge deems fair, which does not necessarily mean equal. This is where historical trends show men facing severe and unexpected financial exposure. The court will analyze a multitude of factors: the length of the marriage, the earning capacity of each spouse, the age and physical health of the parties, and the standard of living established during the relationship. If Robert's spouse sacrificed her earning potential to manage the household or raise children, the court may award her a significantly larger percentage of the physical assets to offset her projected future income deficit. We must heavily analyze the academic data surrounding the initiation of these proceedings. Sociological researchers have consistently tracked a phenomenon where women initiate a staggering majority of divorces, hovering around 70% broadly and nearing 90% among college-educated demographics. Why is this occurring with such statistical regularity? The academic discourse points toward a collision between evolving societal roles and stagnant domestic realities. Studies from institutions like the American Sociological Association indicate that while women have achieved unprecedented economic independence in the modern workforce, the expectations within the traditional American marriage have not evolved at the same velocity. Researchers frequently cite the stalled gender revolution, where women report bearing an unequal burden of emotional labor and domestic management, leading to a profound decrease in marital satisfaction over time. Conversely, the data shows that men consistently report higher levels of marital satisfaction and are frequently caught entirely off guard when the dissolution is initiated. This psychological blind spot is deeply tied to what psychologists term the male deficit model of emotional intimacy. In traditional American socialization, men are frequently conditioned to isolate their emotional vulnerability, relying almost exclusively on their spouses for psychological support and intimate communication. When the marriage ends, the wife often has a robust, pre-existing network of social support, while the husband faces immediate, catastrophic social isolation. This disparity is not merely sad, it is a measurable public health crisis. Longitudinal health studies conducted over the past decade show that divorced men experience a mortality rate significantly higher than married men, driven by spikes in cardiovascular disease, hypertension, and stress-induced immune suppression. The separation process triggers a cascade of physiological stress responses that compound the immediate financial terror of asset division. Let us return to the financial mechanics and the concept of the standard of living drop. A pervasive cultural myth suggests that men emerge from divorce financially unburdened. The rigorous economic tracking paints a much darker reality for the middle and upper middle class. When a dual-income household fractures into two single-income households, the baseline cost of living essentially doubles. The same pool of capital must now fund two mortgages or leases, two sets of utility bills, and two distinct streams of daily expenses. For a man like Robert in our 2026 case study, achieving financial equilibrium is mathematically daunting. He is often ordered to liquidate high-yield retirement assets prematurely, triggering massive tax penalties and permanently crippling the compounding interest curve he relied upon for his future. He may be forced to sell the family home in an unfavorable housing market, simply to satisfy the immediate cash demands of the equitable distribution order. The loss of generational wealth in these scenarios is staggering. frequently wiping out decades of discipline saving in a matter of months. Consider the modern application of spousal support, historically known as alimony. In the mid-20th century, alimony was often a lifelong entitlement designed to support a dependent spouse. By 2026, the academic consensus and statutory guidelines have largely shifted toward rehabilitative support, intended to bridge the gap until the lower-earning spouse can become self-sufficient. However, the calculation models remain highly volatile. Algorithms utilized in various jurisdictions input gross incomes, tax liabilities, and healthcare costs to generate a mandatory support figure. If a man experiences a temporary surge in income prior to the divorce filing, perhaps through a one-time corporate bonus or immense overtime, that inflated figure can be utilized by opposing counsel to establish an artificially high baseline for his earning capacity. The court may then impute income to him, legally demanding he pay support based on a salary he no longer actually earns. Modifying these orders post-judgment requires proving a substantial and material change in circumstances, a legal hurdle that is notoriously difficult and expensive to clear. This systemic wealth destruction is heavily compounded by the staggering cost of the legal apparatus itself. The adversarial nature of the American family court system actively incentivizes protracted conflict. When both parties retain aggressive legal counsel, the marital estate is systematically drained to fund the litigation. We see documented historical trends where middle-class families spend upwards of $50,000 to $100,000 on attorney fees, forensic accountants, and vocational evaluators. This is capital that could have funded college tuitions or secured retirements, completely vaporized in the pursuit of marginal victories in court. Men frequently enter this arena with a mindset of rigorous logic, attempting to argue fairness and historical contribution, only to discover that the family court operates on rigid statutory guidelines and judicial discretion that rarely aligns with a layman's definition of justice. Yet, the division of financial assets, no matter how brutal, is merely the initial skirmish. It is quantifiable, trackable, and ultimately it is just capital. But what happens when the legal framework shifts its gaze from your bank accounts to your bloodline? What happens when the court applies these same sterile, administrative formulas to the time you are permitted to spend with your own children? As we transition from the financial battlefield to the emotional epicenter of marital dissolution, we encounter the most volatile and heavily litigated aspect of modern family law. The stakes rapidly escalate from the preservation of wealth to the preservation of your fundamental parental identity. We are about to examine a specific, highly controversial legal maneuver that has altered countless father-child relationships overnight, a strategic tactic so devastating and frequently utilized in contentious cases that legal scholars and sociologists study its impact constantly. And if you do not know exactly how to identify this maneuver before the paperwork is filed, your entire standing in the court is already fundamentally compromised. The maneuver we must dissect is formally recognized within the legal community as the rapid establishment of the temporary status quo, frequently initiated through an ex parte motion or an emergency temporary order. To understand the gravity of this mechanism, you must first understand a fundamental operating principle of the American family court system. The judiciary intrinsically abhors disruption when it pertains to minor children. Judges are legally mandated to make decisions based on a broad, highly subjective standard known as the best interests of the child. In practical application, this standard heavily favors stability, continuity, and routine. Therefore, whoever dictates the immediate living arrangement of the children at the precise moment the dissolution begins essentially holds a massive, structurally fortified advantage for the remainder of the litigation. Imagine if we examine a deeply illustrative case study from the current year of 2026. Consider a father named Michael residing in the state of Illinois. Michael is deeply involved in his children's lives. He attends the parent-teacher conferences, he manages the evening routines, and he considers himself an equal co-parent. However, as the marital relationship deteriorates, Michael believes they are entering a period of amicable negotiation. He is operating under the assumption of logic and mutual fairness. This is his critical vulnerability. While Michael is attempting to negotiate a collaborative separation informally, opposing counsel advises his spouse to file a petition for dissolution accompanied immediately by a request for temporary primary physical custody, often citing the need for immediate stability or, in highly contentious cases, leveraging exaggerated claims of emotional volatility to secure an emergency order. Because these temporary orders are often granted ex parte, meaning without Michael being present to defend himself or present his own evidence, A new legal reality is codified overnight. Michael comes home to an empty house and a legally binding document stating he is now relegated to the role of a secondary, non-custodial parent, granted visitation rights of perhaps every alternating weekend and one Wednesday evening for dinner. This schedule is known colloquially as the standard visitation model, an archaic framework that immediately reduces a heavily involved father to a marginal, transient figure in his own children's lives. But the true devastation of this maneuver lies in the mechanics of judicial time. In 2026, the family court dockets across the United States are catastrophically backlogged. Michael immediately retains expensive legal counsel to fight this temporary order, but the earliest available hearing date to contest the motion is scheduled 90 to 120 days in the future. During these critical 4 months, the temporary order becomes the operational standard. The children adjust to living primarily with their mother. They establish new daily routines. When Michael finally stands before the judge to argue for shared 50-50 physical custody, he is no longer fighting from a position of equality. He is now fighting against the newly established status quo. Opposing counsel will aggressively argue that disrupting the children's current routine, a routine that has functioned peacefully for the past 4 months, would be detrimental to their psychological well-being. The temporary order, initially granted on paper with zero evidentiary hearing, has organically transformed into the permanent baseline. The judge, adhering to the principle of minimizing disruption, frequently formalizes the temporary arrangement into the final decree. Michael has lost the custody battle before the actual trial even commenced. To comprehend why the legal apparatus defaults to this framework so effortlessly, we must analyze historical trends and the lingering shadow of the tender years doctrine. For over a century in American jurisprudence, the tender years doctrine explicitly dictated that mothers were naturally and biologically superior caretakers for young children. If a divorce occurred, mothers were automatically awarded custody of children under the age of 13 unless the mother was proven profoundly unfit through rigorous, documented evidence of severe neglect. While the United States officially abolished this doctrine in the latter half of the 20th century, replacing it with gender-neutral statutory language, academic sociologists and legal analysts widely agree that the implicit bias of the tender years doctrine heavily saturates the modern judiciary. When a judge looks at a contested custody case, the historical momentum of assigning the mother as the primary domicile and the father as the financial provider remains a powerful, often unspoken psychological undercurrent. This judicial bias directly contradicts decades of peer-reviewed developmental psychology and sociological data. Contemporary academic literature demonstrates unequivocally that the active, consistent presence of a father is one of the single most crucial metrics for a child's long-term success. Extensive studies from institutions dedicated to child development show that children with active, equally involved fathers exhibit drastically lower rates of juvenile delinquency, significantly higher academic achievement, and profoundly better emotional regulation metrics. The data proves that fathers are not secondary parents or mere financial resources. They are an absolute developmental necessity. Yet, the systemic application of family law frequently ignores this empirical data in favor of administrative convenience and historical precedent. When a man like Michael decides to fight the entrenched status quo, he faces astronomical financial and psychological barriers. To overturn a temporary primary custody order, he must request the appointment of a guardian ad litem or a forensic custody evaluator. These are private, highly paid professionals appointed by the court to investigate the family dynamic, interview the children, and issue a recommendation to the judge. The retainer for a forensic evaluator in 2026 can easily exceed $10,000 to $15,000, a cost generally split between the parties or placed entirely on the higher-earning spouse. The process involves deeply invasive psychological testing, home visits, and interrogations regarding every aspect of his personal life. It transforms the sacred bond of fatherhood into a sterile, clinical investigation where every minor mistake or expression of frustration is meticulously documented and potentially weaponized in court. The systemic restructuring of a father's role from a primary caregiver to an intermittent visitor triggers a profound crisis of identity. This is not merely a legal defeat, it is an amputation of purpose. We are looking at a system that legally mandates the marginalization of capable men under the guise of child welfare. But what happens to the human biological machine when it is subjected to this specific prolonged trauma? When you combine the catastrophic financial liquidation of the marital estate with the agonizing systemic separation from one's own children, You create a perfect storm for physiological collapse. The academic community has tracked exactly what occurs within the male nervous system during this prolonged litigation phase, and the resulting public health data is terrifying. We must now turn our attention to the clinical reality of the male deficit model under extreme duress, examining exactly how the family court apparatus inadvertently engineers a measurable, frequently lethal spike in male mortality, and how this psychological degradation is subsequently used against them in the courtroom. When the legal system initiates the systematic dismantling of a man's life, the human body does not differentiate between legal peril and physical danger. The biological stress response is immediate, severe, and scientifically measurable. To understand how the family court apparatus weaponizes a man's psychological degradation, we must first examine the clinical reality of what happens to the male nervous system during the initial phases of a highly contested divorce. Sociologists and evolutionary biologists have extensively documented the male deficit model of emotional socialization in the United States. From early childhood, American men are heavily conditioned to externalize success, suppress vulnerability, and internalize distress. As a direct result of this socialization, a vast majority of adult men rely almost exclusively on their spouses as their sole emotional confidant and psychological support system. They do not typically cultivate the expansive interwoven networks of emotional support that women historically build and maintain. Therefore, when the marital contract is abruptly severed, the man does not merely lose a partner. He loses the entirety of his emotional infrastructure overnight. This sudden, catastrophic social isolation triggers an intense physiological reaction. Academic studies tracking public health consistently show that divorced men in the United States experience drastically elevated levels of cortisol, the body's primary stress hormone. Prolonged exposure to high cortisol levels during the grueling months of initial litigation leads to a phenomenon known as allostatic overload. This manifests clinically as severe insomnia, rapid weight loss, cognitive brain fog, and acute situational depression. Furthermore, public health data demonstrates a deeply alarming historical trend where men undergoing marital dissolution suffer from a significantly higher risk of stress-induced cardiovascular events and represent a massive, disproportionate percentage of adult suicides. This is not an indication of inherent emotional weakness. It is a predictable, biologically documented response to acute, prolonged trauma compounded by total social isolation and the very real threat of losing access to one's children and financial lifeblood. Now, we must examine the specific systemic asymmetry that makes this biological reality so legally dangerous. Researchers in marital dynamics often refer to a highly prevalent sociological pattern, colloquially known as the walkaway wife syndrome, though in academic circles it is better described as uncoupled emotional processing. Statistical data reveals that the partner who initiates the divorce, which is overwhelmingly the wife in the United States, has typically spent 12 to 24 months emotionally processing the end of the marriage before ever filing the formal legal petition. During this pre-filing period, the initiator grieves the relationship, secures a support network, consults with legal professionals, and achieves a state of emotional regulation regarding the separation. They enter the courtroom fully prepared, calm, and highly focused. Conversely, the non-initiating husband is frequently thrust into day one of intense, acute trauma on the exact day he is served with the dissolution papers. Imagine if we observe a case study from the current year of 2026. Consider David, a 38-year-old software engineer living in Seattle, Washington. David has just been served with divorce papers and an accompanying ex parte temporary order that immediately restricts his access to his 2 young daughters to 4 days a month. David is suddenly thrust into the physiological crisis of allostatic overload. He is unable to sleep, his work performance plummets, and he is experiencing overwhelming situational anxiety. Recognizing that he is in crisis and wanting to be the best possible father, David makes a fundamentally logical and medically responsible decision. He seeks the help of a licensed clinical therapist to process his grief and develop coping mechanisms for his newly shattered reality. In any other medical or social context, seeking professional help during a crisis is universally lauded as a sign of maturity and resilience. However, in the hyper-adversarial arena of the American family court system, David has just unwittingly handed opposing counsel a loaded weapon. The weaponization of mental health in custody disputes is a highly effective, deeply cynical legal strategy, utilizing the meticulous discovery process. During a contentious custody battle, opposing counsel can and frequently will subpoena David's medical records, including the clinical intake notes from his newly acquired therapist. Those notes, written by a clinician observing a man in the throes of acute, system-induced trauma, will naturally document symptoms of severe anxiety, depression, and emotional instability. During a sworn deposition or a cross-examination in open court, opposing counsel will strategically isolate these clinical terms, stripping them of all context regarding the divorce itself. They will present these records to the judge not as evidence of a man dealing with a temporary situational crisis caused by the removal of his children, but as definitive proof of a chronic, underlying psychological instability that renders him an unfit parent. This creates a devastating catch-22 for men navigating the system. If David attempts to suppress his emotions and presents as stoic or analytical in court, opposing counsel will frame him as cold, unfeeling, and lacking the necessary empathy to be a primary caregiver. If he exhibits visible distress, sorrow, or admits to seeking psychological counseling, he is immediately labeled as emotionally volatile, erratic, and potentially dangerous to the children's well-being. The judge, bound by the highly subjective best interests of the child standard, is naturally risk-averse. When presented with one parent who appears emotionally regulated, having had a 2-year head start on the grieving process, and another parent who is actively manifesting the clinical symptoms of acute trauma, the court defaults to the perceived safer option. The judge formalizes the temporary restrictive custody order, thereby punishing the father for exhibiting the exact physiological trauma that the court's own immediate severance of his family inherently caused. David is now legally required to defend his own sanity. He may be ordered to undergo extensive psychological evaluations by court-appointed forensic psychiatrists, a process that can easily cost upwards of $10,000 to $15,000 out of his own heavily depleted pocket. He is placed under a judicial microscope where every frustrated text message, every missed hour of sleep, and every natural expression of grief is meticulously logged, pathologized, and utilized to justify his continued marginalization from his daughter's lives. The system fundamentally breaks a man down, observes his broken state, and then utilizes that very brokenness as the legal justification to deny him his parental rights. But what happens when a father anticipates this psychological warfare? What happens when a man manages to maintain his composure, shield his medical privacy, secure highly competent legal representation, and systematically dismantle the opposing counsel's narrative of instability? What occurs when logic, resilience, and unyielding factual evidence begin to actually turn the tide in the courtroom, threatening the temporary status quo, and signaling a potential victory for equal shared parenting? When the standard tactics of emotional weaponization and financial attrition fail to force a father into submission, the adversarial apparatus frequently escalates to its most extreme, constitutionally terrifying mechanism. It is a tactical maneuver so legally destructive that it bypasses standard evidentiary rules entirely, possessing the power to instantly evict a man from his own property, permanently sever his relationship with his children, and brand him with a criminal stigma before he has ever had the opportunity to speak a single word in his own defense. Understanding the mechanics and the historical proliferation of this specific maneuver is not merely a legal exercise. It is an absolute matter of survival in the modern courtroom. The legal maneuver we must now examine is formally categorized as the ex parte civil protection order, though within the corridors of family law academia and amongst seasoned domestic relations practitioners, it is frequently referred to as the silver bullet tactic. To understand the catastrophic power of this mechanism, we must first recognize that the American judicial system was fundamentally designed around the concept of due process. In a criminal court, if the state wishes to deprive you of your property or your liberty, they must prove your guilt beyond a reasonable doubt after affording you a comprehensive opportunity to present a defense. However, the family court system operates under entirely different constitutional parameters, specifically when addressing allegations of domestic instability. The civil protection order allows a petitioner to bypass the standard evidentiary hearings entirely. By submitting a sworn affidavit claiming a subjective fear of imminent harm, a spouse can secure a legally binding judicial order that acts with the immediate, devastating force of a criminal indictment, completely entirely in your absence. Imagine if we analyze a highly representative case study from this current year of 2026. Consider James, a 42-year-old licensed architect and devoted father residing in the state of Virginia. James has absolutely no criminal record, no history of violence, and has spent 2 decades building a stellar professional reputation. As his marriage enters its final highly contentious stages, he and his spouse engage in a loud, emotionally charged, but strictly non-physical verbal argument regarding the division of marital debt. Recognizing the escalating tension, James exercises restraint, leaves the residence to allow the situation to decompress, and spends the night at a local hotel. This is a fundamentally responsible de-escalation tactic. Yet, the following morning, while seated at his architectural firm, James is approached by uniformed law enforcement officers. He is publicly served with an ex parte restraining order. In an instant, based solely on a one-sided piece of paper claiming that his spouse felt threatened by his tone of voice, James's reality is entirely fractured. The immediate, legally mandated consequences of this single document are staggering. James is instantaneously evicted from the home he purchased and continues to finance. He is legally prohibited from coming within 500 feet of his own property, meaning he cannot retrieve his clothing, his financial documents, or his personal effects. He is immediately stripped of his Second Amendment rights, requiring the mandatory surrender of any firearms to local law enforcement. Most devastatingly, he is categorically barred from any contact, direct or indirect, with his own children. A single text message inquiring about his daughter's school day is now a criminal violation, a distinct arrestable offense that carries mandatory jail time. He is transformed from a respected professional and active father into a legally designated threat to society, all before a single shred of objective evidence has been presented, cross-examined, or verified by a neutral arbiter. To understand why a judge would authorize such a draconian deprivation of civil liberties without a preliminary hearing, we must look at the immense systemic pressures placed upon the modern judiciary. Family court judges operate under an overwhelming abundance of caution paradigm. If a judge denies a temporary protective order and the petitioner is subsequently injured, the judge faces absolute political ruin, intense media scrutiny, and potential removal from the bench. Conversely, if a judge grants a protective order based on exaggerated or entirely fabricated claims, there is virtually zero professional consequence to the magistrate. Therefore, the systemic incentive is to rubber stamp the ex parte request, remove the accused male from the domicile, and push the burden of proof to an evidentiary hearing scheduled 2 to 3 weeks in the future. The court views this as a temporary necessary safety measure. For the man subjected to it, it is a point of total socioeconomic and psychological destruction. During those excruciating weeks awaiting his hearing, James is forced to mount a desperate defense against quasi-criminal allegations. He must immediately retain specialized legal counsel, requiring a massive influx of capital, often upwards of $10,000 to $15,000 just to prepare for the return hearing. Because he is locked out of the marital home and his access to joint financial accounts is frequently frozen or heavily contested during this period, he is driven into high-interest debt simply to secure temporary housing and legal representation. The psychological toll is immense. He must inform his employer of the legal situation, severely damaging his professional standing. He is suddenly isolated from his children, who are left confused and traumatized by his abrupt, unexplained disappearance, a narrative that the opposing spouse now controls entirely. When the evidentiary hearing finally occurs, the burden of proof required to sustain the order is remarkably low. Unlike criminal court, the civil family court operates on the preponderance of the evidence standard, meaning the judge only needs to believe that it is 51% likely that the alleged behavior occurred. However, historical trends and sociological tracking reveal a fascinating and dark reality regarding the silver bullet tactic. In a significant percentage of high-conflict divorces, the restraining order is eventually dropped or dismissed by the judge for lack of evidence. James's attorney systematically dismantles the timeline, proves the allegations were exaggerated for tactical gain, and the judge clears James's name. The order is vacated. James has won the hearing. But this victory is an absolute illusion. The strategic objective of the silver bullet was never necessarily to secure a permanent restraining order. The objective was to fundamentally alter the battlefield before the divorce negotiations even began. Even though the order was dropped, the damage is irreversible. Opposing counsel has successfully utilized the court to forcefully evict James from the marital home, granting the spouse exclusive use and possession of the property without having to argue for it in a standard motion. Furthermore, tying directly back to our previous analysis of the status quo, the children have now spent nearly a month living exclusively with their mother while James was legally prohibited from seeing them. The baseline of primary maternal custody has been aggressively, artificially established. James returns to the divorce proceedings completely exhausted, financially depleted by the defense of false allegations, and carrying the lingering, unspoken stigma of having been accused of domestic instability. This mechanism is the ultimate exertion of leverage. It forces a man into a purely defensive posture, fighting desperately to reclaim his basic rights and his fundamental reputation, rather than intelligently negotiating the equitable division of his assets or a fair parenting plan. He is conditioned to accept highly unfavorable settlement terms simply to make the nightmare stop. The weaponization of civil protection orders in the United States represents one of the most profound systemic vulnerabilities facing men in the modern legal apparatus, transforming the necessary shield of domestic violence protection into a highly effective sword, utilized for strategic asset acquisition and custody monopolization. But once a man survives this initial shockwave, whether through rigorous legal defense or sheer endurance, the battlefield shifts once again. The focus turns from the immediate deprivation of liberty to the forensic, microscopic dissection of a lifetime of labor. We must now examine the silent, mathematically brutal phase of the dissolution process, where unseen financial landmines, complex tax liabilities, and the hidden mechanisms of deferred compensation threaten to permanently cripple a man's economic future before he even realizes his capital is gone. The financial battlefield of marital dissolution is rarely a straightforward division of liquid cash. It is a highly complex, mathematically perilous arena where the fundamental misunderstanding of tax classifications and asset liquidity frequently leads to catastrophic, long-term wealth destruction. Academic economists and certified divorce financial analysts consistently observe a pervasive cognitive bias among men entering the settlement phase: the illusion of the equal split. To thoroughly dismantle this illusion, we must examine the clinical mechanics of property division in the modern era, and expose the specific legal instruments that silently drain a man's net worth. Consider a highly representative case study from the year 2026. Let us analyze the financial architecture of William, a 50-year-old senior corporate director residing in the state of New Jersey. William and his spouse are dissolving a 20-year marriage. Their primary marital estate consists of $1 million in total assets, split evenly between a primary residence with $500,000 in pure equity, and William's heavily funded retirement account, which also holds exactly $500,000. During the mediation process, a seemingly logical and fair settlement is proposed. William's spouse will retain the primary residence to maintain stability for the family, and William will retain the entirety of his retirement account. On paper, this is a perfect 50-50 division. Both parties walk away with $500,000. However, under the rigorous scrutiny of federal tax law and forensic accounting, William has just unwittingly agreed to a mathematically devastating compromise. The discrepancy lies in the critical difference between pre-tax assets and post-tax liquidity. The $500,000 in home equity is generally a highly protected, liquid-adjacent asset. If the spouse chooses to sell the home, historical trends in tax legislation, specifically the capital gains exclusions for primary residences, heavily shelter that profit from federal taxation. The spouse receives $500,000 in actual, usable capital. William's asset, conversely, is entirely illusory in its current state. His retirement account is funded with pre-tax dollars. When William eventually reaches the qualifying age and begins to withdraw those funds, every single dollar is subject to ordinary income tax. Depending on his future tax bracket, that $500,000 asset is practically worth roughly $350,000 in actual purchasing power. Furthermore, if William requires immediate liquidity to purchase a new home or furnish a new apartment following the divorce, any early withdrawal from that account triggers a massive mandatory federal penalty on top of the income tax. William assumed he was negotiating an equal split, but the structural realities of the tax code have effectively penalized him by hundreds of thousands of dollars. This leads us directly into the highly complex administrative process of the Qualified Domestic Relations Order, universally known in the legal community as the QDRO. If William and his spouse had decided to divide the retirement account instead of trading it for the house, the court would issue a QDRO to legally sever the federally protected account. This is not a simple banking transfer. The QDRO is a highly specialized, separate legal decree that must be drafted by niche attorneys, approved by the divorce judge, and then rigidly vetted by the corporate plan administrator of William's employer. This process routinely takes 6 to 12 months to complete. During this agonizing administrative limbo, the American stock market continues to fluctuate. If the broader market experiences a severe downturn during those 10 months, historical precedent dictates that the spouse frequently still receives their exact, fixed dollar amount awarded on the date of separation. while William absorbs the entirety of the market loss from his remaining half. Yet, the QDRO is relatively straightforward compared to the most dangerous financial landmine facing the modern American professional: the division of deferred compensation, specifically restricted stock units and executive stock options. In the modern corporate landscape of 2026, base salaries are frequently eclipsed by these complex equity awards. Let us look closely at William's compensation package. He receives annual grants of restricted stock units that vest over a multi-year cliff. These units are unvested, meaning he does not actually own the stock yet. It is merely a corporate promise contingent upon his continued future employment and performance. However, family courts across the United States routinely classify these unvested, phantom shares as divisible marital property if the initial grant occurred during the timeline of the marriage. The resulting legal formulas applied to these shares create an astonishing disparity in risk assumption. The court utilizes specific fractional formulas, historically derived from landmark appellate cases, to determine exactly how many of William's future, unvested shares belong to his spouse. Because these shares cannot be legally transferred or liquidated today, William is frequently ordered to execute a cash buyout of the spouse's projected portion, based on the stock's current market value. This requires William to hand over liquid, post-tax cash today for an asset he may never actually receive. If William is terminated from his position, or if the company's stock value plummets before the vesting date, he suffers a total, unrecoverable capital loss. His ex-spouse, however, has already walked away with the guaranteed cash equivalent. The legal system effectively forces the man to absorb 100% of the future corporate and market risk, while guaranteeing the departing spouse a completely risk-free, immediate financial payout. This massive extraction of capital is heavily compounded by the demographic reality of the gray divorce phenomenon. Sociologists and demographers track a staggering statistical surge in marital dissolution among adults aged 50 and older over the past 2 decades. For a man like William, losing 50 to 60% of his total net worth at age 50 is not merely a temporary setback, it is a permanent systemic shock. The mathematical principles of compound interest require time, a resource that older men fundamentally lack. He cannot simply work another 30 years to rebuild the portfolio. Academic studies focusing on the post-divorce economic mobility of older men show a chilling historical trend. A massive percentage are forced to permanently downgrade their standard of living, delay retirement indefinitely, and remain in the active workforce well into their late 70s simply to survive the macroeconomic impact of the asset division. Simultaneously, we must examine the modern reality of spousal support under current federal tax paradigms. Prior to recent sweeping legislative tax reforms, alimony payments were historically tax-deductible for the payer, providing a slight structural relief for the higher-earning male. Today, that deduction has been entirely eliminated at the federal level. If William is ordered to pay $3,000 a month in rehabilitative spousal support, he must generate that payment using strictly post-tax dollars. To yield $3,000 of net, usable cash, William must actually earn significantly more in gross corporate income, paying taxes on money he will never see. The state essentially forces him to subsidize the ex-spouse with heavily taxed income, while the recipient receives the money entirely tax-free. The math becomes utterly suffocating. But the liquidation of static assets and the imposition of spousal support is still bound by the parameters of what a man currently earns and what he currently owns. The true terror of the family court financial apparatus lies in its ability to completely ignore reality and legally mandate payments based on a highly subjective, purely theoretical calculation of what a judge believes you should be earning. When the court shifts its focus from spousal maintenance to the rigid, algorithmic enforcement of state child support guidelines, the rules of basic economics are entirely suspended. You are about to discover how the state utilizes a devastating legal mechanism known as the imputation of income, a tactic that possesses the power to bankrupt a man based on hypothetical salaries, phantom earning capacities, and statistical averages that have absolutely no bearing on his actual lived reality. The legal mechanism known as the imputation of income is a profound sociological phenomenon and a terrifying reality within the American family court system. To fully grasp its impact, we must understand the original legislative intent behind it. Historically, the imputation of income was designed as a protective legal barrier. It was created to prevent malicious actors from intentionally quitting high-paying jobs or deliberately hiding assets in order to artificially impoverish themselves and thereby evade their lawful child support or spousal maintenance obligations. In theory, this is a perfectly logical safeguard. However, historical trends and extensive academic review of family court dockets reveal a massive, systemic misapplication of this principle. The judicial apparatus, heavily burdened by caseloads and reliant on rigid statutory formulas, frequently applies this punitive measure not to men who are maliciously hiding wealth, but to men who are the victims of involuntary macroeconomic shifts, corporate downsizing, or severe health crises. Imagine if we examine a deeply illustrative case study from this current year of 2026. Consider Thomas, a 48-year-old supply chain executive residing in the state of Michigan. For the past decade, Thomas earned an impressive base salary of $160,000. However, the modern American economy is highly volatile. Due to widespread automation and artificial intelligence integration within the logistics sector, Thomas's corporation undergoes massive restructuring, and his specific executive role is permanently eliminated. Despite engaging in a rigorous, deeply documented job hunt for 8 months, the only comparable position Thomas can secure in his regional market offers a base salary of $85,000. He takes the job out of necessity to maintain cash flow and health insurance for his family. Shortly thereafter, his spouse files for marital dissolution. When the case reaches the financial calculation phase, logic dictates that the court should utilize Thomas's actual, current salary of $85,000 to determine his monthly support obligations. This is his lived reality. However, opposing counsel files a motion alleging that Thomas is voluntarily underemployed. They argue that because he historically earned $160,000, he possesses the inherent capacity to earn that amount today. To substantiate this claim, the court frequently authorizes the appointment of a vocational evaluator. This introduces an entirely new layer of administrative expense and pseudoscientific forecasting into the litigation. The vocational evaluator is a private expert, frequently paid thousands of dollars out of Thomas's own pocket, tasked with analyzing his resume, his past W-2 forms, and generalized Department of Labor statistics. The evaluator produces a highly clinical report indicating that, based on statistical averages in the broader Midwest region, someone with Thomas's specific educational background and tenure should be earning his previous higher salary. This report entirely ignores the nuanced reality of Thomas's localized industry collapse, the age discrimination inherent in corporate hiring, and the actual empirical evidence of his 8-month job search. The family court judge, lacking an advanced degree in macroeconomics and heavily relying on the evaluator's report, issues a ruling that legally imputes Thomas's income at $160,000. The mathematical devastation of this ruling is absolute. The state child support algorithms and spousal maintenance formulas are now calculated based on a phantom salary that Thomas does not actually receive. He is ordered to pay perhaps $4,000 a month in combined support. However, his actual net take-home pay from his $85,000 job, after federal taxes, state taxes, and basic deductions, is roughly $5,000. The court has just legally mandated that Thomas hand over 80% of his actual liquid income. He is left with $1,000 a month to secure housing, purchase food, maintain transportation, and pay off the massive legal debts accrued during the divorce process itself. The system has structurally engineered his inevitable financial collapse by pretending he exists in a completely different economic reality. When Thomas inevitably fails to make these mathematically impossible payments, he encounters the most draconian enforcement mechanism remaining in modern American jurisprudence. There is a pervasive cultural myth that the United States abolished debtors' prisons in the 19th century. While true for civil consumer debt, it is entirely false regarding family court obligations. Child support and court-ordered alimony are uniquely categorized obligations. If Thomas falls behind on his payments, his ex-spouse can file a motion for contempt of court. In a contempt hearing, the judge does not re-evaluate Thomas's inability to pay. The judge only looks at the mathematical fact that the imputed order was violated. Because the court has already legally decided that Thomas possesses the capacity to earn the money, his failure to pay is legally classified as willful disobedience. The state enforcement apparatus then activates with terrifying velocity. Potential outcomes for willful contempt include the immediate suspension of Thomas's driver's license. This creates a devastating paradox. The state demands he earn more money while simultaneously removing his legal ability to commute to a workplace. The state can revoke his passport, freeze his bank accounts, intercept his tax refunds, and suspend any professional licenses he holds, entirely destroying his career trajectory. And if the arrears continue to accumulate, The family court judge possesses the unilateral authority to order Thomas to be incarcerated in a county jail for contempt. He is stripped of his freedom not for committing a violent crime, but for failing to satisfy a financial algorithm based on a hypothetical income fabricated by a vocational evaluator. Furthermore, historical trends concerning the federal Bradley Amendment, enacted in 1986, mandate that child support arrears can never be retroactively forgiven or modified by a judge, even if the original calculation was fundamentally flawed. If Thomas accrues $50,000 in debt because he could not meet the imputed payments, that debt is permanent. It compounds with high state-mandated interest rates. It cannot be discharged in federal bankruptcy court. It will follow him until the day he dies, acting as a permanent, unshakable anchor on his economic mobility. The legal system transforms a man from an active economic participant into a perpetual indentured servant to a mathematical fiction. Yet, as horrifying as the weaponization of hypothetical finances may be, it remains an attack on a man's external resources. It dictates where he lives, what he drives, and how long he must labor. But there is an even darker, far more insidious tactical maneuver employed in the most high-conflict marital dissolutions. It is a psychological strategy so profoundly destructive that clinical psychologists and child development experts consider it a form of severe emotional abuse. What happens when the battlefield shifts from the courtroom ledger into the actual neuroplasticity of your children's minds? What happens when a highly motivated opposing party utilizes the structural isolation we discussed earlier not just to distance you physically, but to actively, systematically rewrite your child's memories, replacing their inherent love and affection for you with manufactured fear and clinical hostility? We must now examine the devastating clinical reality of maternal gatekeeping and the deeply controversial, frequently misunderstood psychological phenomenon that has the power to erase a father's identity entirely. To understand the clinical reality of maternal gatekeeping and the subsequent weaponization of a child's psychology, we must first define these terms strictly within the parameters of developmental sociology and forensic psychology. Maternal gatekeeping is an academic term utilized to describe a spectrum of behaviors where the primary custodial parent, historically and statistically the mother, actively controls, filters, or restricts the non-custodial parent's access to the children. In its mildest forms, it manifests as administrative friction. It is the accidental failure to forward a school newsletter, the convenient forgetting of a scheduled phone call, or the subtle, disapproving sigh when the child mentions having fun with their father. However, in the crucible of a high-conflict marital dissolution, this gatekeeping rapidly metastasizes into a severe, clinically recognized pathology known as parental alienation. This is not merely a byproduct of a bitter divorce. It is a systematic, targeted campaign of psychological programming designed to completely sever the biological and emotional bond between a father and his child. Imagine if we analyze the horrific trajectory of a case study from the current year of 2026. Consider Richard, a 40-year-old pediatric surgeon living in Massachusetts. Richard has spent his entire adult life dedicated to healing children, and has historically been a profoundly loving, deeply involved father to his 9-year-old son. As the divorce litigation extends into its second agonizing year, Richard begins to notice a chilling transformation in his son's behavior during their highly restricted, court-ordered visitation weekends. His son, who previously ran to the door to greet him, now stands rigidly in the driveway, refusing eye contact. The child begins regurgitating complex adult vocabulary and specific legal grievances that directly mirror the opposing counsel's court filings. He accuses Richard of not paying enough money, of ruining the family, and of being inherently dangerous, utilizing phrases that a 9-year-old simply does not organically possess. Richard is witnessing the real-time alteration of his child's neuroplasticity. The academic community has extensively documented exactly how this psychological restructuring is achieved. The alienating parent frequently utilizes a mechanism known as the loyalty bind, heavily intertwined with trauma bonding techniques. Because the court system has already established the temporary status quo, granting the mother primary physical custody, the child is entirely dependent upon her for daily survival, emotional regulation, and psychological safety. The alienating parent begins to project their own unresolved marital grievances, their anger, and their anxieties directly onto the child. They treat the child not as a developing dependent, but as a peer confidant and an emotional surrogate. The child quickly learns a devastating subconscious lesson. Expressing any love, affection, or even neutral curiosity about their father results in the immediate withdrawal of love from their mother. To survive this terrifying emotional minefield, the child biologically and psychologically adapts. They align completely with the primary custodian, absorbing the mother's hatred as their own subjective reality. The rejection of the father is not a genuine loss of affection. It is a desperate, engineered psychological survival mechanism. When Richard attempts to bring this clinical abuse to the attention of the family court, he encounters a catastrophic systemic failure. Family court magistrates are legal scholars trained in statutory interpretation and asset division. They are rarely licensed clinical psychologists. When Richard testifies that his ex-spouse is systematically brainwashing their son, his desperate pleas frequently fall on deaf ears. To an untrained judge managing a highly backlogged 2026 docket, Richard's legitimate claims of parental alienation sound exactly like the standard, bitter complaining of a disgruntled ex-husband. The opposing counsel will aggressively counter-argue that the child is simply reacting naturally to Richard's alleged poor parenting, utilizing the child's newly manifested hostility as retroactive proof that Richard deserves to be marginalized. To definitively prove parental alienation, Richard must petition the court for the appointment of a highly specialized forensic psychologist to conduct an exhaustive family evaluation. This introduces a staggering financial and temporal burden. In 2026, a comprehensive forensic evaluation specifically targeting alienation can easily cost $20,000 to $30,000 and require 6 to 9 months to complete. During this agonizing waiting period, the child remains under the absolute, unrestricted control of the alienating parent, allowing the psychological programming to calcify into permanent neural pathways. The most devastating paradox of this entire phenomenon occurs when the court attempts to respect the autonomy of the child. In many jurisdictions, once a child reaches a certain age, frequently 12 or 14, judges will conduct an in-camera interview, bringing the child into the judge's private chambers to ask their preference regarding the custody arrangement. When the judge asks Richard's heavily alienated son where he wishes to live, the child, fully indoctrinated and absolutely terrified of the alienating parent's potential wrath, explicitly states that he hates his father and never wishes to see him again. The judge, operating under the highly subjective best interests of the child standard, takes the child's statement at face value. The court formally codifies the psychological abuse by stripping Richard of his remaining visitation rights, effectively validating the alienating parent's campaign. The legal system legally sanitizes the complete erasure of a father's identity. Historical trends and longitudinal public health studies tracking the victims of severe parental alienation paint a terrifying picture of the long-term potential outcomes. Developmental psychologists have found that children who are successfully alienated from a loving parent experience catastrophic psychological trauma in their adult lives. Because their foundational understanding of love was built upon conditions, manipulation, and the forced severance of a primary biological bond, these children exhibit statistically massive spikes in clinical depression, substance abuse disorders, and a profound inability to form healthy, trusting romantic relationships. The generational damage inflicted by the family court's inability to swiftly identify and halt maternal gatekeeping is an unquantifiable public health crisis. Richard has now traversed the absolute nadir of the marital dissolution process. He has faced the immediate shock of the ex parte status quo, endured the systemic depletion of his capital through the imputation of hypothetical income, and witnessed the agonizing psychological erasure of his own child. He is financially decimated, emotionally exhausted, and structurally isolated. And yet, the litigation must eventually conclude. The endless motions, the forensic evaluations, and the deposition transcripts all eventually coalesce into a single binding stack of paper. The trial ends. The judge issues the ruling. But what exactly happens in the immediate aftermath when the gavel finally falls and the temporary nightmare transforms into a permanent, inescapable legal decree? How does a man successfully transition from the hypervigilance of active courtroom warfare into the desolate, unfamiliar landscape of the post-divorce reality? And what are the precise, data-driven frameworks required to actually survive the immediate fallout? The moment the final decree of dissolution is stamped by the county clerk, the adrenaline that has fueled a man for months or even years suddenly evaporates. Psychologists and sociologists who study acute legal trauma refer to this immediate aftermath as post-litigation decompression. For the duration of the trial, your central nervous system was locked in a state of continuous threat assessment. You were anticipating the next motion, the next deposition, the next terrifying email from opposing counsel. When that external threat matrix is abruptly removed, the biological reaction is rarely relief. Instead, it is frequently characterized by a profound, clinical exhaustion coupled with a terrifying sense of void. You are no longer fighting for your life. You are now tasked with actually living the structurally diminished life the court has legally mandated. This transition requires a radical pivot from a defensive, adversarial posture into a strictly operational, data-driven reconstruction phase. Imagine if we look at the reality of Christopher, a 35-year-old regional logistics manager living in Texas in this current year of 2026. Christopher has just finalized a grueling 18-month dissolution process. He moves his remaining personal effects into a vastly downsized one-bedroom apartment. The silence of that first weekend alone is deafening. The financial reality of the court order is no longer a theoretical calculation on a spreadsheet. It is a direct, algorithmic withdrawal from his biweekly paycheck. The state garnishes his wages for child support before the money ever touches his account. He is left with a fractional percentage of his former gross income, yet his baseline operational costs regarding rent, utilities, food, and transportation remain rigid. If Christopher allows the resentment of this mathematical asymmetry to dictate his daily behavior, historical trends indicate he will enter a downward spiral of financial delinquency and profound clinical depression. To survive, Christopher must deploy a specialized cognitive framework. The first and most critical framework is the intentional dismantling of the male deficit model we explored earlier. In the post-divorce landscape, social isolation is a lethal metric. Christopher cannot rely on his former shared social circle, which statistically fractures and frequently aligns with the custodial mother due to the proximity of the children. He must actively engineer a new social infrastructure. Academic studies in male psychology demonstrate that men bond and process trauma most effectively through shared, shoulder-to-shoulder objectives, rather than face-to-face clinical vulnerability. Therefore, the data suggests joining structured, goal-oriented communities. This is not about superficial networking. It is about establishing a biological baseline of community to regulate cortisol levels. Furthermore, the utilization of cognitive behavioral therapy becomes essential. Christopher must learn to clinically separate the unjust nature of the family court system from his own daily operational reality. The system's inherent bias is an objective fact, but ruminating on that fact provides zero tactical advantage. Acceptance of the new baseline is the mandatory first step of reconstruction. Once the psychological baseline is stabilized, the focus must immediately shift to the forensic execution of a zero-based post-dissolution budget. The wealth destruction of the divorce is a sunk cost. Christopher must conduct a ruthless audit of his remaining capital. Every single recurring subscription, every variable expense, and every lingering joint liability must be identified and severed. In 2026, the macroeconomic environment is unforgiving. Relying on historical spending habits will lead to insolvency. Christopher must adopt an aggressively defensive financial posture, prioritizing the establishment of a localized emergency fund over any attempt to recreate his previous standard of living. He must mathematically calculate his exact break-even point under the new taxation and support garnishment realities. This step-by-step financial triage is not an admission of defeat. It is the establishment of a fortified economic bunker from which he can eventually launch a secondary wealth accumulation phase. By removing the emotion from the ledger and treating his personal finances with the cold, sterile efficiency of a corporate restructuring, he reclaims his agency. The final and arguably most volatile framework involves the day-to-day execution of the court-ordered parenting plan. In the immediate aftermath of a high-conflict divorce, the cultural expectation of amicable co-parenting is entirely unrealistic and frequently dangerous. Academic child development specialists increasingly recommend a highly structured protocol known as parallel parenting for high-conflict uncouplings. In parallel parenting, Christopher and his ex-spouse operate essentially as completely independent entities. There is no shared decision-making regarding minor daily routines, no joint attendance at extracurricular activities unless strictly mandated, and absolutely no phone calls. All communication is reduced to a strictly monitored, legally admissible digital application. When Christopher communicates, he must utilize a method keeping messages brief, informative, friendly, and firm. He must strip every communication of emotion, accusation, or defense. He treats his ex-spouse exactly as he would a volatile, highly litigious corporate client. This rigid boundary setting fundamentally starves the conflict of oxygen. It protects Christopher from further false allegations, and most importantly, it shields the children from being utilized as communication conduits or emotional collateral. Christopher, by strictly adhering to these data-driven psychological, financial, and operational frameworks, slowly begins to stabilize. The acute trauma subsides into a manageable chronic reality. He pays his mandated support, he maximizes the highly restricted time he has with his children, and he slowly begins to accumulate a marginal surplus of capital. He survives the immediate fallout. But mere survival is not the ultimate objective of this academic discourse. As the years progress and the dust of the legal explosion finally settles, a new horizon inevitably approaches. The demographic data reveals that the vast majority of divorced men will eventually re-enter the dating market, and many will consider signing a second marital contract. But how do you navigate the prospect of future relationships when you possess an intimate, forensic knowledge of the systemic apparatus designed to dismantle your assets? How do you protect your newly rebuilt capital, shield your children from blended family litigation, and ensure that you never walk blindly into the exact same structural vulnerability twice? We must now examine the ultimate defensive strategies, the unshakable legal parameters of asset protection, and the sociological reality of the post-divorce American man, as he steps out of the wreckage and attempts to reclaim his absolute sovereignty. To fully comprehend the sociological reality of the post-divorce American man, as he steps out of the wreckage and attempts to reclaim his absolute sovereignty, we must analyze the statistical inevitability of the next phase. In the year 2026, rigorous demographic models and longitudinal relationship studies indicate that an overwhelming majority of divorced men will eventually re-enter the dating market, and a significant percentage will actively consider signing a second marital contract or entering into a long-term cohabitation agreement. However, stepping back into the sociological arena of modern dating, after surviving the systemic, highly optimized extraction process of the family court apparatus, requires a fundamentally altered psychological framework. You are no longer the naive participant operating on romantic assumptions. You are a veteran of a highly adversarial legal system. This transition requires the immediate, unflinching implementation of strict, uncompromising asset protection before any emotional commitment is formalized. The academic data surrounding second marriages presents a stark mathematical reality check. The dissolution rate for second marriages is historically much higher than for first marriages, consistently hovering near 65%. If a man enters a second marital contract utilizing the exact same lack of legal preparation as his first, he is mathematically courting total, unrecoverable financial annihilation. Imagine if we observe the trajectory of Mark, a 46-year-old corporate consultant residing in the state of Florida, during this current year of 2026. Mark survived a grueling 3-year divorce that liquidated exactly half of his foundational wealth and subjected him to intense psychological strain. 5 years later, his investment portfolio is slowly stabilizing, his corporate career has advanced, and he is deeply involved with a new partner. The cultural and emotional pressure to simply merge their lives seamlessly, to buy a joint home and combine bank accounts, is immense. However, Mark understands the historical trends. He knows that love is an emotion, but marriage is a legally binding corporate merger governed by the state legislature. Therefore, before cohabitation, and absolutely before the issuance of a second marriage license, Mark initiates the execution of an unshakable prenuptial agreement. Historically, prenuptial agreements were culturally stigmatized, frequently viewed as weapons of the ultra-wealthy or indicators of inherent romantic distrust. By 2026, the academic, economic, and legal consensus has shifted entirely. A prenuptial agreement is now universally recognized by certified financial analysts and estate planners as the absolute baseline of responsible domestic planning. But the execution of this document must be flawless to withstand future judicial scrutiny. It is not simply a piece of paper signed over dinner. To be legally unassailable, the document must adhere to rigid, step-by-step procedural standards. First, there must be a complete, exhaustive, and forensically accurate disclosure of all assets and liabilities by both parties. If Mark hides a single offshore account, a minor equity stake in a startup, or even a significant cryptocurrency holding, the entire agreement can be entirely invalidated by a judge during a future dispute due to fraudulent non-disclosure. Second, both parties must be represented by independent, board-certified family law attorneys. If Mark's partner utilizes Mark's attorney, or waives her right to legal counsel entirely to save money, opposing counsel in a future divorce will aggressively argue that the agreement was signed under duress or without informed legal consent. This is a primary tactic utilized to void the contract. Furthermore, The agreement must definitively address the waiver of future spousal support and clearly classify the appreciation of premarital assets. The prenuptial agreement effectively removes the state's default, algorithmic asset division formulas from the equation, replacing them with a private, mutually negotiated corporate framework while both parties are still in a state of deep affection, logical clarity, and rational negotiation. But protecting against the potential outcomes of a second divorce is only one fraction of the legal architecture required for absolute sovereignty. We must plunge deeply into the highly volatile, frequently overlooked arena of blended family estate planning. When a divorced father remarries or cohabitates, he inherently creates a structurally complex web of competing legal and financial interests. Imagine if Mark were to unexpectedly pass away without a rigorously updated estate plan. Under the default intestate probate laws of most United States jurisdictions, his new spouse is legally entitled to a massive percentage, often an elective share, of his entire estate, entirely bypassing the children from his first marriage. The historical trends in county probate courts are completely saturated with horrific, wealth-destroying litigation where a surviving second spouse battles the deceased man's biological children for the remaining capital. The legal fees in these probate battles frequently consume the very estate they are fighting over. To completely neutralize this generational threat, relying on a simple last will and testament is fundamentally insufficient. A standard will guarantees that your assets will travel through the public, highly expensive, and easily contested probate court system. Instead, the data-driven approach utilized by high-net-worth individuals and recommended by academic estate scholars involves the immediate establishment of a revocable living trust. Mark works with specialized counsel to transfer the legal ownership of his primary residence, his non-retirement investment accounts, and his liquid capital out of his individual name and directly into the trust. Because the trust is an immortal legal entity that never dies, it now owns the assets, and there is absolutely no probate process required upon Mark's passing. The trust document acts as a rigid private corporate charter. Mark can explicitly stipulate through precise legal mechanisms that upon his passing, his current spouse receives a lifetime right to reside in the property and receive a modest income, but upon her death, the principal capital irrevocably bypasses her bloodline and transfers exclusively to Mark's biological children. This specific legal mechanism prevents the unintentional disinheritance of a man's lineage, a devastating potential outcome that statistically occurs at an alarming rate in modern blended families. Reclaiming absolute sovereignty is not an abstract emotional state of being. It is a meticulously constructed, legally fortified reality. It is the conscious transition from a passive, highly vulnerable participant in the American judicial system to an active, educated architect of your own unassailable framework. The men who successfully navigate the post-divorce landscape do not succumb to permanent bitterness, nor do they retreat into perpetual, fearful isolation. Instead, they transform the catastrophic loss of their initial marital dissolution into the ultimate educational catalyst. They study the sociological data, they comprehend the macroeconomic realities of spousal support imputation and tax liabilities, and they employ specialized legal counsel not merely to fight active fires, but to proactively build impenetrable firewalls. They recognize that their capital, their psychological stability, and their direct, uninterrupted relationship with their children are the most critical assets they will ever manage in their lifetime. By establishing bulletproof corporate structures, impenetrable trusts, and rigorous behavioral boundaries, they refuse to ever again surrender the operational control of those assets to the discretionary whims of a family court judge or a heavily biased administrative algorithm. You now possess the comprehensive academic discourse, the historical trends, and the precise clinical terminology necessary to thoroughly understand the exact machinery of the modern dissolution system. But understanding the academic theory is merely the prerequisite for taking immediate, physical action. The true test of your resilience begins the exact moment you brutally evaluate your own specific vulnerabilities. Are you currently operating under the catastrophic illusion of an equal financial split? Have you accurately mapped the potential outcomes of your specific state's equitable distribution statutes against your current unvested corporate equity or your highly leveraged real estate portfolio? The theoretical masterclass regarding the systemic apparatus concludes here, but the active deployment of these defensive strategies is an ongoing, lifelong discipline. In the upcoming intensive examinations, we will shift entirely from the broad sociological overview into the highly specialized, granular execution of advanced offshore asset protection trusts, complex corporate shielding structures, and the specific highly guarded tax loopholes utilized by the top 1% to legally starve the litigation apparatus before a lawsuit can even be filed. You have finally stepped out of the dark and recognized the battlefield for what it truly is. But the real engineering of your permanent, unshakable independence is only just beginning.